Good day, everyone. My name is Ernest, and I will be facilitating our webinar on Build Your Solid Workforce, How Australian Trade Employers Can Hire Overseas Tradies Before the Rush. First and foremost, I would like to share with you who we are and what we do. So, we are No Borders Law Group, and NB Migration Law is part of No Borders Law Group, which was formed in 2022 with four key divisions: commercial law, employment law, migration law, and property law. Before that, No Borders Migration Advocates was founded in 1998, so our migration team has been helping people with Australian visa matters for 28 years. At NB Migration Law, we focus on providing clear and practical migration advice for individuals, families, and businesses. We assist with wide range of visa matters, including family visas, employer-sponsored visas, and more complex migration cases. We are problem solvers, and our goal is to find the right legal solution for each client's situation. No Borders Law Group is built around helping people find a way forward. At the heart of what we do is people. Every visa represents a new opportunity, a family being reunited, or new beginning in Australia. That is why we are passionate about helping our clients move forward with confidence. And now, I would like to introduce to you our speaker for today. So there you have it. If you have any questions, inquiries, or clarifications, please feel free to drop them in the comment section, and we will attend to them during the Q&A session. Welcome and enjoy the session.
Good morning, everybody. Actually, I think good afternoon. We are about 5 minutes after 12 o'clock, at least in Queensland, okay? And I am very privileged to talk about our topics and how we can, help you guys in business to getting more skilled people working in your industry or in your field, okay? The topic what we're covering today is going to be about fast-tracking TRA application. EJ, please, the slide where, yes, thank you so much, okay? So we are going to talk about TRA fast-tracked applications, approve what we require for to be an approved sponsor, DAMA and labor agreements, compliance issues. Actually, I think compliance issues recently really coming up with the Department of Home Affairs. We are seeing a number of compliance requests from the department in recent times. So it means that they're monitoring the employees more in recent times, okay? And we have the 482 and the pathway to permanent residency. Next slide. Okay. So as we are all aware of the current situation, mainly in a construction industry, the department and the government has come together and tried to support to bringing in skilled people and approving their visas currently in Australia. As you can see, we are about 35,000 people less than what we would require to fill the gap and really support our construction industry. And the government is committed $85 million to improve the skills assessment and the required needs for these occupations. And also, as we are all aware, 2032, the Olympic is very soon upon us. I mean, it's about 6 years away, but 6 years is going like this. And I'm not sure how the department will combat with this. Now, there is one very important aspect, and this is always one of my weak points regarding to the decisions what the department has made a number of years ago, why we require so many international employees or candidates from overseas, or even candidates who are in Australia on certain visas, to get a sponsored work visa. The real difficulty for our clients is the SAF level. Now, if the department and the government is so committed, and maybe I am very political here, and forgive me for that, but if they are so committed to skilling Australia and getting all that and taking the money from the employers, $1,200, $1,400, $1,800 per year, $5,000, $3,000 under the 186 visa process, I think we should have been in a much better position. And certainly we should have been in a much better position to assessing these trade skills much faster than what we do. As you all know, Trades Recognition Australia, plus other bodies who are required to do the skills assessment, they are assessing skills 6 months, 8 months. I mean, sometimes with TASES, which can be a RTO approved provider on their trades recognition, they can maybe fast track some of the skills assessment. But really, 6 to 8 months is a pretty long time. And if you would like to bring in international candidates, how are you going to wait for that long? Okay, maybe the job even is not there anymore because it had to be filled with someone else. So I think there are a lot of challenges in this space, but as I said, the government tried to work on this. As you all know, in a professional space, especially for nurses and medical specialists, they brought in new assessments, which is an expedited assessment. And we don't talk about this right now because that's another topic and another industry, but they started with that. And then also in 2024, they brought in a specific fast track process for tradespeople in a construction industry. So if you can get the next slides. Yes. So if you can see, these are some of the occupations what trades recognition is fast tracking, and they assessing them faster. Do you have another slice of that, EJ, or can you check that for me, please? Seconds, just the next slide, please. Yes, no, just go back to the previous slide, please. Okay, there is something which doesn't show here on the slides, but certain countries, and for example, China, Ireland, Republic of Korea, Sri Lanka, United Arab Emirates, United Kingdom, in some instances, United States, they getting a faster assessment on this fast track application. It could be 2 months, probably, what TRA is offering for this type of occupation. So you have the list here. You can see what type of occupation they are supporting. And as you can see, they mostly in construction industry. As you can see, carpenter, drainer, electrician, some of the occupations require licensing in Australia, and that takes a little bit longer. But some electricians can work, as you all know, with provisional license, where they can apply to the electrical board and they get a provisional license, same as with the plumbers. But under the 482 regime, for some occupation, now I'm talking about this fast track, but I'm not talking about all the occupations, because as you know, you have the OSAP, which is the Overseas Skilled Occupation Assessment, which for certain countries has to go through a rigorous skills assessment. But under this fast track for these special countries, it is very important that they can get assessed within 2 months, So that's something which the government is supporting right now, and TRA is very committed to. Also, sometimes when your candidate is here in Australia and they are holding a visa which would expire in a near future, then you can provide evidence of the visa expiry, and you can seek priority assessment. Now, it's always in their discretion to approve it or not to approve it. All right. So that's something which is very important to know. We were successful in the past with a few priority assessment applications on the TRA, and we were able to get it approved faster. And do you have any question about this? Anybody has any question about this? Have you ever come across with fast tracking with TRA? Anybody would like to share some of their experiences? No? Okay, next slide, please. Okay, so the new TRA fast track program, okay, that's as we said, the government is contributing about 85 million to the fast track application process, okay, allows businesses to plan the workforce much better, okay, and in a timely fashion. Policy signal that's not in force yet. Okay, this is under policy discussion, but what is that means? The government is actively incentivizing skilled migration, early movers gain advantage, target trades, electrician, plumbers, carpenters, welders, and other high in demand occupations. Okay, but as I said, this fast track occupation is available under TRA. Next slide. Okay. Becoming an approved sponsor, I am absolutely sure that most of you have done already sponsorship, okay, and employed overseas candidates, but it's always good to reiterate what is required, and if there anything else what maybe we can contribute to your knowledge. Okay, so as you all know, becoming a standard business sponsor, you require to demonstrate that you are lawfully operating in Australia, and lawful operation is usually having an ABN registration. Now, it's not necessary that you require a company. A sponsor can be a sole trader or partnership. Pardon me, especially in accounting or legal space or some of the professional field. You may have partnerships, so they are also available to sponsor people. But it just needs to be very carefully prepared, because depends of what ABN number you are using. But you require to demonstrate that the business is lawfully operating, and lawful operation is usually also requires a registered tax information. So the company is lodging their business activity statement, and they have profit, or not so much profit. Really, profit is not that important, but what is mostly important, that has a revenue which can support the salary of a new candidate. That is something which is very important. Profit is also important, because if you're putting a new employee on a job and you don't have enough money left in a till to pay the wages, that can adversely affect or impact on the process. So it's important that you demonstrate the financial ability and also an organizational chart. So sometimes you would like to bring in a person, and maybe there is already another person in that position, so you need to carefully consider the organizational chart. Also, you need to carefully prepare the organizational chart to show who are they reporting to, because sometimes you may have an occupation that requires that the person reports to the CEO or to senior management, and in organizational much are they reporting to someone else. So these are very important, intricate informations when you prepare the standard business sponsorship. But as you know, the standard business sponsorship is valid for 5 years. And during that 5 years, you have to do different nomination based on available occupation, what you would like to fill, okay? And to fill those occupations, you would require a nomination, a separate nomination, okay? So currently the processing time of the standard business sponsorship is about 8 weeks, all right? And usually, I mean, we hardly ever see a refusal of the standard business sponsorship. It mainly happens when it's a new business, right? And we have many questions from clients. Okay, we are only operating for 6 months. What is the requirement in that instance? Okay. And this is something which we can assist the client with, but mostly you really require a substantial business plan to demonstrate what the business is going to do in the next 3 years. Say, if in that instance, maybe the department requires you to provide a lease agreement. And if the lease agreement is only 2 years or 1 year, then how you want to demonstrate that the candidate who you bring in will work in a business for 4 years. So we have seen refusals from clients where they had the lease agreement for 1 year and then the department refused the application and then they came to us, okay? So it is very important when you have a new business, you have these documents ready. I mean, you can provide a lease agreement as 1 year plus 2 years, or 1 year plus 1 year plus 1 year, or 3 years plus 3 years. So, because then the business has an opportunity to cancel the lease agreement at the second instance, so that you can refuse to extend it further. But this is something which is very important. Also, if the facility, the business would have a funding available. So sometimes the business may have an overdraft facility because the business owner could offer security over the overdraft. These are all very important for a newly started business, okay? But this is the process. And as I said, it takes about 4 to 8 weeks to get approved. There is also something which is very important, that if you have clients who are doing sponsorship and they have done a number of sponsorship in the past years and their turnover, even with associated entities, and I think sometimes that gets neglected, but if they have associated entities and the turnover is over 4 million and they sponsored a number of visa applicants under the standard business sponsorship, they can seek accreditation, okay, and they can become an accredited sponsor. This is extremely important because the processing time is much faster. Sometimes, a nomination can be approved in a couple of days, and that can be extremely beneficial for the business. Anybody has any question about this? No? Okay. Next slide, please, EJ.
We actually do have one question from Jacqueline Agnes.
Yes.
Her question is there any company revenue requirement to be eligible to become an approved sponsor?
There is not really a requirement to become a standard business sponsorship. As I said, for an accredited sponsorship is $4 million revenue, but to become a standard business sponsorship, there is no requirement. So if you are a sole trader and you have $250,000 revenue, you still can sponsor someone. It's always depends on the salary, the expenses, and how much you're offering to the prospective employee. So it has to be in aligned, and it has to demonstrate, the documentation has to demonstrate that you are able to pay the relevant salary for the following 2 or 3 years. Sometimes say, I done a sponsorship for a small painting company, and they may have $400,000 revenue. They had about 3-4 employees. So we were able to get everything approved for them based on existing, past, and future contracts, what they negotiated with the building, sorry, it's called builders, because, when you're working in a painting industry, you're offering services for the builders. And the building company has provided evidence that, yeah, in the past 3 years, this was the value what we offered. And for the future, we would continue offering the same engagement. No problem to get it approved, okay? So it's each application is on its own merits, but certainly this is the key aspect to get the sponsorship approved. Demonstrate that the business can pay the ongoing expenses and also the salary of the future employee, okay? Did I answer your question, Jackie?
Yes, that's right. Thank you, Agnes.
Thank you. Okay, EJ, next slide, please. Okay. So as you are all aware, you know what type of pathways we have for employer-sponsored pathways, all right? And as we discussed briefly, the 482 stream. And then after the 482 stream, we have the 186, or we have the 186, which is a permanent stream. You can have a direct entry stream. You can have a transitional stream, okay? And we have the regional sponsorship. So if your business is operating in a regional area, there are different rules applies, and that is for the whole country. We just mentioned here, Queensland, because we're operating in different states in Australia, but at the moment I'm talking mostly to people from Queensland. So the Gold Coast, the Sunshine Coast, Toowoomba, Cairns, Townsville, so Emerald. We're recently doing a number of applications from Emerald. So these are all regional areas. So just go back to the subclass 482. It is very important, as I mentioned, that under the subclass 482, you have a 5-year sponsorship validity. Okay, so during that time, you can sponsor anyone who you like, but you require nomination for each sponsors, or it's called nominating the position, okay? And sometimes the client is misinterpret, and they say, yeah, we're sponsoring someone. Yeah, you're sponsoring someone, but actually you nominating the position, and the visa application will apply, or visa applicant will apply for the visa based on that nomination, okay? And as you all know, I just briefly run through, okay, of the requirements for the nomination. You require, in some instances, you require labor market testing, okay, which has to run for 28 days. It is very important. I actually came across some information, but I haven't really investigated this, and I would like to investigate that. MIA provided some information on Gumtree advertising, because some of the companies are maybe advertising on Gumtree. At the moment, my understanding is not accepted in immigration, by immigration, and also LinkedIn advertising is usually not accepted if it's not in a public space. But for the sake of clean cut, I just say always to the client, Gumtree and LinkedIn is generally not accepted for advertising. So you need to run the ad for 28 days. Very important, the content of the advertising, and we are here to support you in that, okay? Further, we're going to talk about it later. From 1st of July, the salary level will increase to 79,490 or something in that nature. But I always say to the client, do $80,000 or $81,000, because it's just better looking, more appropriate when you do the application. But also remember, for the salary, you also require market rate. And sometimes people forget, okay, when you also do the market rate analysis, you need to do it in a same location or very closely, located advertising. You have to check and calculate the market rate. So if someone wants to employ someone in Keynes, don't get the market rate calculation from Sydney salary level, okay? Mostly is rather if you want to employ someone in Brisbane, you may use a salary level in Keynes, which can be lower, but in Brisbane is higher. So it's very intricate, but very important, okay? So must meet market rate and also must meet the minimum salary threshold. From 1st of July, it's about $80,000. And your occupation has to be on a skilled list, which is an SID list, okay? Once you have all this, then the visa applicant applies. And as you all know, the visa applicant has to have minimum 1 year full-time experience in a position. And also the visa applicant must have the relevant qualification prescribed by ENSCO or equivalent minimum 3 years work experience or 5 years. It depends on your occupation, okay? So that's in a nutshell of the 482. The 186 is different, and I see recently that applicants really would like to, and especially if someone is holding in Australia 485 visa, because as you know, in a regional area, that can be extended, not just 2 years, but can be 3 years. So if a candidate would have 3 years experience in a position and they're working on a 485 visa for the employer, they actually would be eligible for a direct entry. It's just for the direct entry 186 visa. And they can go directly from a 485 to the 186 visa. And I always say to the employers, don't be so, scared that, if we're sponsoring them, they're going to leave, blah, 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 blah. It's not really, because it takes about 16 to 18 months to get a nomination approved, okay, or the visa approved. So they will still have the employee. And if there is a good relationship, then the employee can be with the employer for a lifetime. As I mentioned many times in my presentations, I have one of my employees who I sponsored. You won't believe this. 18 years ago, 18 years ago, and he's still with me. So if you have a good relationship, then I think that's very important that maybe the employer is committed to a direct entry 186. Requirement 3 years full-time experience. Salary, all that jazz is the same as under the 482, and the occupation has to be on the list. Now you need to be careful though, because sometimes direct entry 186, the occupation may be not on the list, okay? So it's just everything has to be double checked before, a business would go ahead with that application. The transitional sponsorship, yeah, and one more thing, they have to have level 6 English, okay? Under the 482, level 5, under the 186, level 6, and it has to be within the last 3 years. The transitional stream requires that these people worked with the employer for 2 years under the 482 visa. But the good news is it's not exactly 2 years, so not exactly 24 months, but the last week of the 24 months, they can apply for the 186. The key issue is, key element to that, they cannot take any unpaid leave. Okay, so they have to continue working with the employer if they in Australia, and they're not taking unpaid leave. If someone is coming from overseas, I would strongly recommend to do 3 years sponsorship, 3 years nomination, because if they're missing the entry and they cannot come here for a month, then they won't be eligible for the 186. So better to do initially a 3-year sponsorship, okay? So that's the 186 direct entry and transitional. For the transitional, really, you require all the pay slips, okay, that you paid everything according to the 482 undertaking. The 494 regional visa is again very similar to the 186 direct entry. It is a temporary regime and it is available for certain occupations, okay? Different occupations, okay? Maybe for the position is not on, or the occupation is not on the 482 stream, but it's on the 494. Example, restaurant manager, okay? Or facility, that there is something under the facility manager that they are not on a 482. Or if they are on a 482, maybe the facility manager is on a high salary. As you know, there is the special occupation, special highly skilled position, and also the core skilled. Okay, that's under the 482 regime. So if the position requires $146,000 salary, but it's available in a regional area. In a regional area, it's not required to be paid 146,000, but it's, and then, you know, many companies has different locations. Like I'm working with a big cleaning company who has offices on the Sunshine Coast, and they were able to sponsor someone in their Sunshine Coast location, not in a Brisbane location. So, you know, it is all look at the whole picture and then find the best solution for the business. But as I said, different occupations under the 494. Salary is the same, not the high level salary. There is no requirement, but minimum $80,000. 3 years work experience, skills assessment, and level 6 English. We also require to get the approval from the regional certifying body. That is the RCB, okay? And that's done by local councils or chambers of commerces everywhere in Australia. Anybody has any question?
We do have one, Agnes.
Yes.
How difficult is it for overseas tradespeople to obtain skills assessments?
Okay, very good question. It is depend what country you are talking about, because countries are all different and different requirements. What country we talking about? EJ, do we have the?
We don't have any follow-up
No, no,
questions
no,
regarding
no, no,
that.
no. Do we know what countries our questionnaire was asking about?
I think it's just in general,
In
Agnes.
general, okay. So in general, the situation is we require overseas qualification, okay, which has to be equivalent to an Australian qualification. Say sometimes, you know, some countries there is a lower level of qualification, or they just done, you know, some people, say for example in Italy, okay, and I'm talking about, you know, a country which, you know, the world dominating, one of the world dominating country, they do qualification in high school, okay? And I remember in my good old times in Hungary, as I am Hungarian, we also done different occupations in high school. So after you were 15 years of age, you turned 18 in 3 years, you obtained those qualifications in high school. These qualifications are not accepted in Australia. So you really need to look at the qualification has to be equivalent to an Australian qualification, which is usually Cert 3 for a trades occupation, and look at the number of years of experience. Now, especially from Vietnam, from Thailand, from Philippines, from Papua New Guinea, from Fiji, you might get paid in cash, okay? And you wouldn't be able to claim those work experiences. So it's extremely important that you check the reference, the payment, and also the qualification. And if you have all the three, it's an acceptable, relevant to the Australian assessment, then you will have no problem, okay? But certain countries require skills assessment through the OSEP program, and we can, you know, we can send you, if you have any question, we can send you the OSEP program. And mainly, you know, Brazil, Fiji, Thailand, in some occupation, even the United Kingdom, but it's very limited. It used to be most of the time. And probably for reason being is a lot of Indian people moved to England, or a lot of people from the Middle East moved to England. So they might claim we are British passport holders, but the qualification obtained in another country. So therefore, they wanted those occupations assessed under this OSEP. But Philippines, all these countries require an OSEP assessment for certain occupation, and TRA is providing the occupation list. So if you are a welder from South Africa, you would require a skills assessment. If you are a motor mechanic from the Philippines, okay, you require a skills assessment. Now, very interestingly, I had an inquiry once. We haven't progressed anywhere because the company said they're not sponsoring anyone. They wanted, it was an outboard motor, like they were selling small boats with outboard motor. And, you would think you need a motor mechanic, right? And I said to the guys, no, you need a small engine mechanic. And small engine mechanic didn't require skills assessment from the Philippines. So these are the intricate information what a migration law firm can assist you guys, and we can look into all this. But the OSEP requires a very rigorous skills assessment. They need to provide the assessment of the documentation. They need to do hands-on tests, okay? So they can do it locally or closely, like some countries like Philippines, we have an assessing authority, but in certain countries we don't. So they need to apply via, it's called, previously it's called Sky, but I think now just through Teams or whatever. So they need to demonstrate how they do things hands-on, okay? Because an assessor can see, okay, this is how they hold the instrument or the equipment. This person is really not in this occupation. By the other one who really knows what they do, the assessor can establish that. They require that as well. And there is a third one. So that's the hands-on one. And there is another one which they need to do. So 3 steps. And that is done by a RTO organization. And after that, they have this assessment. They get a third 3. And that's when they can have the full skills assessment. Okay. So that's for certain countries, certain occupation under the trade is very, very important, okay? So that's what you would require to see. Otherwise, like Germany, United States, France, Spain, they just a normal skills assessment. But for the 482, for most of the countries, if they are not on this OSEP list, they don't require skills assessment. Also, they don't require skills assessment from certain countries, even if they are under the OSEP, if they are air condition mechanic. Okay, so it's just all over the place, and therefore it is important that we check everything for every occupation. All right. Next slide, DJ. Yes.
I want to ask a question.
Yes, please.
Yeah, what about how long takes to have the ANC as to sponsor people to be approved as a
for the nomination? It depends. It could be 5 to 6 months usually. That's the approval of the nomination.
Okay, thank you.
Okay, and that can be onshore, can be offshore, depends on a company. If the organization is a big Australian company, like they have 200-300 employees, then it's certainly faster. If it's a small business, it sometimes take longer. Okay, it's all in a whole concept. Okay.
All right, thanks.
Thank you so much. All right, now we have the DAMA and labor agreements. DAMA is, as you all know, this is the designated area migration assessment, okay? And we have certain locations. In Queensland at the moment, we have Cairns and Townsville. There are some discussion with the government, which I have become aware from the Migration Queensland, there are some communication with the government that they would like to have the whole Queensland to become a DAMA approved place, just like in South Australia and in WA. Okay, so it is a good concept, and it gives a lot of discount or concession to sponsor overseas candidates, and they have their own skilled occupation list, which I think can change every year. I mean, North Queensland supposed to change the occupation, and I think they added and they removed some this year. They can change it, and you need to be aware of, that you always look at the recent occupation list. But the good news is with the DAMA, you would be able to, the steps for the DAMA, first of all, you have to seek an endorsement, okay, from the local approval, which could be the council or business Townsville or whatever it's called. You need to seek the approval from them. It's called approved endorsement. Once you have the endorsement, then you can apply on the department's website under the labor agreement, and it's an overarching labor agreement. And once you apply for the labor agreement, then you can do your nomination just as you do it under the 482 regime. And once you've done the nomination, then you can also lodge the visa application. These two, the nomination and the visa application, can be done at the same time. Usually for the endorsement, you require labor market testing. You need to provide evidence of your business activities. But usually these local councils are pretty switched on, and they know what your business is doing. So if you are a good business operator in a local area, or you're working with someone like that, then it's much easier to get things approved, okay? And like, many times when we do canes, the guys know, okay, yeah, we know of this business. Yeah, it's pretty good, so that not much question asked. Otherwise, you really need to provide good business study, why they require international candidate with the labor market testing, demonstrate that they couldn't, find Australian employees. But remember, fantastic availability for different occupations. Like in North Queensland, there are commercial cleaners available. In waitresses, in hospitality industry are available, which is not available in Brisbane or in Sydney or other main cities. So very broad occupation list, and each occupation has a different skills assessment requirement. Sometimes you just need 1 year full-time experience and the candidate can be assessed. Most of the time, even for a 482, if it's not in category 1, I think it's called group 1. Yeah, that's the exact word. If the occupation is in group 1, then you don't require skills assessment. If it's in 3, 4, 5, I think even in group 2, you don't require skills assessment, but I need to double check on that. But in 3, 4, 5, 6, 7, 8, 9, you require skills assessment, but each occupation has a different requirement, okay? So you have the skills assessment. Depends how many years experience the candidate has, who you're sponsoring or the business is sponsoring. You can do a 482 or you can do a 494, okay, application, or the business can do that. Salary can be negotiated, but only by 10%, okay? And that could be important because as your salary level is increasing now to $80,000, you can negotiate 10% down, so you have to pay $72,000 salary under the DAMO, which is a reasonable amount, okay? And that is, in all the DAMO areas, okay? But remember, you also need to meet market rate. Okay, so if the market rate, say we have a business who wants to sponsor quality assurer, right? Then their market rate is about $90 to $100,000. You cannot offer lesser salary. But sometimes under this occupation, you may won't be even given the concession because, the local area knows that these are the market rates, okay? And You also can bring in candidates who are over 45 years of age, because as you know, getting permanent residency for people, it's only under 45 years of age in a normal regime. But under the DAMA, over 45 is fine, up to 55 years of age. And English language concession. Now, if you are someone who is, childhood educator, you can't really get a concession under English language, okay? But, if you are a commercial cleaner, you can certainly have a concession for English language. If they don't achieve level 5, then they need to achieve a minimum of 4.5 overall, okay? So that's the DAMA, and the employer and the employee must be located in the area where the DAMA is available. Okay, so that's something very important. As I said, Western Australia, South Australia, Northern Territory. Northern Territory also available in a whole state, but Queensland is only certain locations. Okay. Labor agreement is an independent labor agreement, which can be company specific, okay? It can be industry specific, which can be, the aged care businesses, which has certain requirements different to any other labor agreements. Salary level under the aged care labor agreement is around $56,000, if I'm correct, maybe 54. I can't remember the numbers. Guys, I do so much, in this space that, sometimes the numbers I always need to look it up. But in this sort of space, also under the aged care, you require an MOU from the what you called the local I just have a monetary labs union. Okay, so you need to have approval from the union under the MOU. Once you have that, and the business is registered under a government licensing, then as an aged care facility, then you can do that. Okay, NDIS usually is not accept. The NDIS, simply NDIS provider who don't have government approved registration, then can't get this aged care labor agreement. Then we have the on-hire labor agreement, because you are a recruitment company or a labor hire company. The recruitment company is different, of course, but the labor hire services, when you provide that, you can seek an on-hire labor agreement. The good news is you don't require any union approval, but you have to pay 20% above the minimum threshold. Okay, so if the minimum threshold is 80,000, you would need to pay the candidate $96,000 under the labor hire agreement. Pretty fast assessment usually is about 4 to 5 months for the on hire. For the aged care facility, it's about 3-4 months. And just remember, under this type of labor agreements, the variation, which previously you could do variation as you grow or as you required other occupations during the year, but now you only can do it once. The variation can be done only once a year, all right? And the good news with the labor agreements, not on hire, because that requires on hire company to employ people in the occupation that is on a skilled occupation list under the 482 regime. But the rest, the company specific you can sponsor people or get into agreement for different occupation that is on a skilled occupation list. Okay, so that's something which is very important to note. Do you have any question?
We do actually have two questions, Agnes.
Lovely, thank you.
One is from Prisha. Do all trades require a skills assessment for 482 sponsorship for candidates from the UK?
Not all. There is something which is specific, and if you look up OSAP, that's called OSOP on the Trades Recognition Australia, you can check. There is a list, there is an occupation, and next to that there is a country which is requiring skills assessment. If United Kingdom is not on that list, then You don't require skills assessment. Okay.
Thank you, Agnes. We have another one.
Mm-hmm.
Would it matter for the 494 subclass if our regional location has only been established less than a month? Our main office is in Brisbane for 5 years.
Perfect, no problem. Long as you can demonstrate that the candidate is going to be there, you require the candidate to be in a regional area, and the candidate lives and works in a regional area for 3 years. The visa is going to be granted usually for 5 years, but after 3 years, the candidate can apply for their own permanent residency. No, look, I sponsored people in Cairns, and I have the head office in Brisbane. Okay, so it's no issue. And then you can have, the candidate going there because you expanding. So that's what it has to be, a genuine business growth that requires the candidate to locate it in a regional area. So if you just sense, because, sometimes my clients are so crafty that they say, oh, okay, we're going to get this employee in a regional area, but can he live in Brisbane? I said, so how is that person going to travel up to Harvey Bay every day? Okay, so you need to be absolutely mindful that it has to be a genuine expansion. If that's genuine expansion, no problem. 1 or 2 months, perfectly fine.
Thank you, Agnes. I think that's all questions we have for now.
Thank you. Next slide, please. Okay. Now, this is something, as I mentioned to you, that the department start to look at more monitoring, okay? And the monitoring is only under the temporary regime. So 482-494, they look at your sponsorship, and then they can go and check. Sometimes maybe there is a unhappy employee who made a complaint to the department, so they checking. Just if you are a genuine employer, you usually don't get monitored. Okay, but if there is something, you don't pay the superannuation correctly, you underpay the wages, like we have a candidate we talked to another day. She has been underpaid in this particular pay year, like, we have, 1st of July to end of June, a payroll year. This financial year, she has been underpaid last year, September, by 2 days, right? So if that's the case, she doesn't meet the requirements because it was underpayment. But I talked to her and I said, your employer can make an adjustment and, pay you the 2 days what they underpaid you. Just make a note to the tax office, okay? Just that was a genuine mistake, a genuine oversight. And then she would be perfectly fine. Okay, so it's always, if someone, like I have another client in Sydney who hasn't been paid for a month. That's a little bit tricky, okay? Because 1 month underpayment can seriously affect on someone's 186 application. So, and that's what the department monitoring under the monitoring regime. But what you require to be aware of, have a proper accounting documentation. I'm sure if you are a reasonable size small business, as we know now, the government says you are a small business under 10 million, okay, or up to 10 million. So even if you are a $500,000 business, then you should have proper accounting documentation. So immigration comes here is the documentation, boom. Also, the department can check, is the visa holder doing the work, what they needed to do based on the sponsorship or actually, again, nomination, okay, because the nomination has the employment contract. Always remember there is a court decision where there was a very interesting court decision, and you might want to hear about this. There was a ballet dancer, right? When every night she had to perform for 3 hours, right? And during the day, she was doing something else because, she didn't work all day. Yeah, maybe practiced, but she didn't work all day. So there was this is an old court case, and the department refused the application because she was, in breach of her sponsorship because she was doing other things than her occupation was, okay, as a ballet dancer. Now, we have an occupation as a dancer, and it's called exotic dancer, okay? I don't know what is that entails and what type of exotic dancers we have, but I have a couple of ideas. But this particular visa holder was a ballet dancer, and the department refused it because she was doing other stuff. However, the court has had that because she was doing her ballet dancing for 3 hours, like you have maybe an hour and then a break and another hour and boom, boom, boom. So she was doing the ballet dancing, but she did additional. So minimum 30% of the tasks what you have been engaged for, you were working in. So the visa was approved for her, okay? Now, you really don't want to go here because your clients as an employer or your clients as a candidate, they don't really want to go to court, okay? But usually the tribunal would approve this and upheld this because this is a federal court decision. And that's the key, that if the candidate does maybe 60-70% of the work, but maybe someone got sick and they need to step in and do something else, that is not so serious, okay? And this is temporary, okay? So it's not an ongoing issue, and it's not an ongoing work what the candidate does. Sometimes, you might gonna improve the position, or you say, okay, you're not just say, you're just a welder, right? Sorry, I'm not saying just a welder because it's an amazing occupation, but they might say you become a team leader, you become a welder supervisor, okay? So they doing more of a managerial task as well, but if that's 30% of their daily work, that is perfectly fine, okay? And then you can explain to the department. So that's not an issue. But just remember, it is really very important that the candidates are doing the same work what they were nominated in, okay? Also, the number of hours, what the candidate has to work. You cannot make the candidate work 50 hours and not pay for that, or make them work on a weekend and not pay for their entitlements. Depends, if the candidate is under the fair work salary structure, then you may have to look at what they need to meet under that requirements, because immigration is going to refer to that. But for that, we have an employment law arm in our business, so that's always beneficial to seek some confirmation for that. But these are the key elements, okay? Now, also sometimes the clients are asking us what is the, downfall sponsoring someone. The only one thing, candidate can leave you if you're sponsoring them, doesn't matter, because under Australian employment law, they can resign, okay? You can also terminate them if you are not happy with them. Remember, if you terminate someone during the 3 years sponsorship, you would get part of the self levy. You could get the self levy back. Okay, so if the candidate works with you for 1 year and you're not satisfied with their employment or their work, and you terminate, and there is still 2 more years, you can reclaim the 2-year self levy, which is $2,400, or depends on the size of the company. So that's available, okay, but they can leave, you can terminate them. Okay, so that's something which under the Australian fair work rules. If the candidate you terminate and they have to return home, you have to pay their repatriation, which means a one-way ticket back to their home country. But really, that's the most biggest impact on the business if the candidate would leave, okay? Also remember, if the business is paying for the candidate's visa application, you can recoup the visa application fee from the candidate during their employment. Not the sponsorship, not the nomination. That is borne by the employer, and you cannot recoup that or ask the candidate to pay you up front. You can't do that, okay, as an employer. But if you committed to pay, many organizations are paying, for the employee, the visa charge, then legal fee and the visa charge you can recoup from the employee, okay? So that's in a nutshell regarding the enforcement of the sponsorship. And of course, if you have any issue, you terminate the employee or whatever, the employee is leaving you, you must notify the Department of Home Affairs within 7 working days. Okay, I mean, if you run out of time, long as you notify the department within reasonable time, then you are covered. Okay, but you cannot just hold on and not to notify the department, because if you want to employ later on people, they can suspend your sponsorship in a softer, way, or they can actually cancel your sponsorship, which may affect other visa holders' visas as well. Okay, I had clients like that, and 3 people were cancelled because the sponsorship was cancelled. Okay, anybody has any question about this? EJ?
I think none so far. There's actually one from Amber.
Yeah.
Uh, from Amber, what are the most common mistakes employers encounter that results to a delayed or rejected sponsorship, and how do they eliminate that risk early?
Regarding the Amber, you asking about once you are an approved sponsor, or you getting a sponsorship approval? Because if you are an approved sponsor, they can cancel your sponsorship based on the information what I just mentioned. Yes.
Once an approved
Okay.
sponsor.
Okay, once you are an approved sponsor, on the payment of wages, that's something which is important. Not paying superannuation, okay, that's something very important. As I said, make the employee work overtime and not remunerating for that. Really, usually that's the most important one, and make the employee do other tasks, mostly different tasks that what they were employed for. Okay, these are the key elements of sometimes can be that you underpaid other employees and you have a fair work decision. Many big companies these days have a enterprise agreement and it's not updated, and they underpaid the wages for their employees. So that can adversely affect any sponsorship. Not that they will refuse the sponsorship, but it's always, or for example, if the company is going bankrupt, right? That can happen. The company goes in administration or go bankrupt and they, folding the business. That can adversely affect. Okay. And there is a question when you applying for the sponsorship, have you been involved in this type of activities? Okay, so if that's happening during the sponsorship, the validity of the sponsorship, that can result in suspension or in cancellation of the sponsorship. Okay, have I answered your question, Amber? You're welcome. Thank you. AJ, next slide. Yes, okay. So these are the things, okay, just very briefly, it's important that you think ahead, you get, the candidates fast-tracked occupation, especially if you're working in a construction space. Other trade businesses are already building their international pipelines. What is that means? That, people are going out and sourcing international candidates. So maybe, you are competing with them. So that's something why you need to consider to act promptly. And again, the 2032 demand is speaking for certain occupations and certain industries. So that's why it's important that you are, getting in action ASAP. Next slide, EJ. Oh, that's good. If anybody has any additional questions, okay, this is an opportunity for you, and I am here available to answer your questions.
Thank you so much, Agnes. So, if anyone has more questions related to our topic for today, you can leave them in the comment section. Or if you have a more complex question, we can also advise that you scan the QR code and feel free to avail our 20-minute free consultation with Agnes or any of our migration law experts here at NB Migration. So, feel free to scan the QR code and we can book you a free consultation.
As I can see, probably there is no more question.
I think yes, we don't have any other questions.
All right.
Um,
To everybody, I would like to wish a very successful next 6 months or a very successful new financial year as we coming to that now. And hopefully you will be able to recruit international candidates, and hopefully we can support your application. I wish you all the very best and thank you for your attendance today. Have a lovely day.